and hope everyone's doing well on this rainy Wednesday morning. Woody Allen once said that 80% of life is just showing up. If I was in an anger management program, I think I would have lost my one-year chip this morning, facing unbelievable traffic in New Hampshire. So, well, good morning. We're going to talk about employment law year in review. That's because this is the New Hampshire High Tech Alliance HR Exchange. And my name is Jim Reedy. This is Sheehan Finney, and we are your hosts. And why is it a year in review in June? Well, because we start our program in September and we run it through to June. And we take July and August off, and then we are back again in September. And it's been really a pretty interesting year, as it usually is with HR professionals and the workplace and employment law. And just quickly, we talked about everything from wage and hour issues to paid leave issues. We dealt with financial wellness, wellness in general. We dealt with FFCRA, CARES Act, and so on. We dealt with just trying to think of some of the other issues. Workplace violence we dealt with this year. We dealt with hiring in a difficult climate, Dave Chulo, and some tips on hiring and so on. So it's been a busy year. And last month we didn't have our program because typically in May we don't, because we have our annual labor and employment law seminar, which was again a great success at the Castleton down in Wyndham. So we picked June for a year in review and as a sort of a look back and a look forward. And June also is the month of which the Supreme Court ends its term from October to June, and Supreme Court usually issues a lot of decisions, and we can expect a few more coming out this week or next. So we're going to talk about that, and we're going to talk about just sort of looking back from the end of 2020 to 2021 and bleeding into this year, and then looking forward on a regulatory and also on a from a legislative standpoint. So if I can, let's see, I have my cursor here, advance.
Hey, Jim, it's Liz. I'm going to share to your screen now, okay?
Great, thank you, Liz.
Let's see here. Sorry, folks, give me just a second.
And that's Liz Tezik in our marketing department, our very capable person who had a panicked call to me saying this morning, Jim, where are you? And I think she heard me growling at the car in front of me. So Liz was certainly here on time and ready to go.
All right, for some reason it's causing issues. It's just gonna be one of those mornings. So Jim, I am just going to share my screen and I'm gonna give you my mouse for this morning. So just give me 2 seconds.
You know, as we're talking about this, for those that, let me just see if I can advance here.
Wiggle your mouse a little bit, you should be good.
It's no go.
There you go.
Yeah, my screen, there we go. Yeah, and boy, isn't that appropriate that we pop up this screen that the upside down world of the Stranger Things, for those that have caught up the latest season. And the whole concept there is a parallel universe and it's an upside down world. And boy, that's what it seems like this morning. Thank God for Liz and helping me out. So hopefully that the upside down world is not the new normal, and hopefully that we're looking to brighter days ahead. And what does that mean? Well, that means that, as we're coming out of the COVID era and going from pandemic to endemic, that doesn't mean there's going to be end to the pandemic. It just means it's going to what's called endemic stage, which means it's more like other things that we face seasonally or otherwise. And for those that are experiencing COVID now, or coworkers experience COVID, it is absolutely still here. The most recent variant. Although what's interesting is, depending upon where you are and who you're exposed to, you may still get the Omicron variant, you may get BA2, or you may get BA5. And that, depending upon what that is, it's different symptoms. So the burden for HR, of course, is to determine, well, not determine, but continue to enforce the screening policies that you would have and respond appropriately, meaning that if someone is exposed to or symptomatic, they're staying home for a period of time, quarantine, and then isolation if they actually have symptoms and tested positive, and then when they can return to work. And the problem with returning to work after the symptoms have subsided, typically CDC says 5 days after symptoms resolve, you still should wear a mask. The problem with testing afterwards is that you could still test positive, even though you can no longer cast the virus. That's sort of the in sum and substance of sort of the craziness that we've been facing the last 2 years, or the unpredictability. So where are we now? With low unemployment, wage inflation, brisk competition, and how COVID has changed the workplace, is this the new normal? And have you adjusted to the new normal? Again, I referenced Dave Ciullo's presentation on issues related to recruitment and hiring from a remote standpoint, or doing remote onboarding, or just otherwise dealing with how the workplace has changed. And I think it's fair to say that HR is in a constant state of adjustment. So before we look forward, let's look back, because COVID still remains on the radar screen. And I think that's important, because not only because we want to look at what happened and how we adjusted and how we have to continue to adjust, but also there are some legal issues that remain from COVID and the COVID era, meaning 2020 and 2021, that we still have to deal with. And it is hard to look back. It's like a bad toothache, perhaps, and certainly not to make fun of COVID or the tragedy that is COVID. Over 1 million people now in the U.S. have lost their lives, which is a horrible, horrible benchmark. And no one ever thought we'd be here going back to, say, February or March of 2020. But sadly, that's where we are. And for those that have had COVID, and I count myself among them, thankfully it wasn't that bad. And for some of us, and we were able to survive. And even though you've had your vaccine and your boosters, you could still get it. And I'm evidence of that, as many of you folks are too. So 2020, probably one of the most challenging years in history. Who would have ever thought that you would actually be dealing with a pandemic in your lifetime? I mean, the last time we truly had a pandemic was the Spanish flu in 1917 and 1918. So most of us were not around then. But dealing with that, and dealing with all the things that came about in 2020 in that regard. And then came 2021, when you thought it was safe to go back to the workplace. 2021 happened. And those challenges, as I said before, have truly continued to shape who we are in the workplace and how we deal with employees. I was doing a presentation yesterday for doing a training session for a client, and we said that the way in which you evaluate remote workers is something that is different from your standard workplace, and we're actually going to talk a bit about that today. So 2021, yes, of course, you have a new administration, a new focus, and with that, agencies like the National Labor Relations Board and the EEOC being an independent commission, but it has its appointments by the incoming president, and certainly influenced by the new administration. And same is true with the National Labor Relations Board, but nothing is more evident than the National Labor Relations Board and how it changes from administration to administration, especially when you switch from one party to the other. And that is because one party, well, let's leave parties aside. Let's say that one shift in the board will be, as we saw from Clinton to Bush, from Bush to Obama, from Obama to Trump, from Trump to now Biden. Each time the National Labor Relations Board has shifted its focus from more of a pro-employer to more of a pro-employee. And that's a simplistic way of looking at it because it's not always that way. It's not always one way or the other. Oftentimes it's a mix. And so this new National Labor Relations Board certainly has a more of a look like what we saw under the Obama administration and under the Clinton administration, more employee focused. But we'll see how that develops. We're only really a year into that, year and a half into that. And we've seen some things where it looks like there is a U-turn from some of the Trump era policies, meaning more employee friendly, less employer friendly, but it's not an absolute. Of course, in 2021, we saw an extension through the American Rescue Plan of we saw it even before the American Rescue Plan of the FFCRA extension, first into March, and then parts of it through the American Rescue Plan, which had also a COBRA element to it for purposes of extending the COBRA period and COBRA subsidies. Now looking back, there are questions to whether or not the American Rescue Plan was necessary, given where we were with the virus at that point. But there's no doubt that the economy took a real hit in 2020, and it was still recovering. And arguably till today, it is still recovering from the many effects of COBRA and what it meant. And again, if you look back to 2020, in March and April shutdowns, and while you had the FFCRA and the CARES Act, you had these waves of the infection and the impact upon industries with stay-at-home orders and state of emergency claims and so on. And 2021, just like 2020, saw the CDC trying to do their very best to understand the trajectory of the virus and providing guidance. First, it was only wear a mask if you have the illness. Otherwise, don't wear it. Then it went to everyone wear a mask. Then it went to, yes, for a period of time, double mask, which was certainly challenging. And then it went back to masking in the workplace and then no mask. And now, of course, if you go forward to where we are today, the CDC came out with guidance just this week saying, if you're traveling, and some cities have done the same, and as close as Boston, when you're back inside in closed spaces, you should be wearing a mask again. But I'm traveling this weekend to the SHRM conference and in New Orleans, and they're recommending wearing masks, one, because of COVID, and two, because of monkeypox. My cursor is sort of stuck here. Let's see what's going on. There we go. Nope. Well, I don't know what's happening with our screen this morning. Just bear with me for 1 second, please. And we're back. All right, sorry about that. Federal employees with regard to the mandates. So we know about the mandates that came about in September of 2021 under the path of the pandemic, the administration's attempt to really deal with the surge in August, September, and October of COVID, and we all saw that happening. And it was hydra-headed. It was federal employees, no exemptions, federal contractors, federal employees, fully mandated by a certain point where there were no exemptions. Federal contractors, if you were covered by the federal contractor rule and you had contracts in the works or solicitations in the works or a contract during the set period of time last fall, you had to have your workforce fully vaccinated. And there were questions about their exemptions, religious and medical. The healthcare CMS, which is Medicare, Medicaid, covered employers had to have fully vaccinated workplace, but they had exemptions for religious and medical, and there were questions about that as well, and certainly and how that was applied. We're going to talk about the exemptions in a minute. And then OSHA offered its first ETS standard, which is emergency temporary standards, and then its second one that came out later. And then you had the OSHA ETS, which was 100 or more employees, and that was challenged as well. And we started to see district court and then appeals court challenges to the mandate. And then after that, the Supreme Court ruled, and we'll talk about that in a second. But there were questions that remained. And all the while, before the president came out with Path Out of the Pandemic, of course, if you go back to December of 2020, when the first vaccine came out, the Pfizer vaccine, EEOC on December 16th, I think it was 2020, issued its guidance with regard to vaccine mandates. And then in the spring rather, they amended it again to change it a bit, especially with regard to religious exemptions, but allowing for exemptions, medical and religious, in early on in the process, and providing some guidance, then refining its guidance in spring of 2021. So in other words, employers, private sector employers and public sector employers could have a vaccine mandate long before Path Out of the Pandemic. And then when challenged by the courts up until the Supreme Court, and now afterwards, employers still could have a vaccine mandate. And what is that? It is when you have the EEOC says if it is job related, the vaccine mandate is job related and consistent with business necessity. And so that left it sort of wide open. We originally thought it was hospitals, nursing homes, and similar facilities, but the EEOC didn't provide those bumpers. It was basically if it is job related and consistent with business necessity. And so a lot of employers still have, and that is, we're seeing the rise in infections again, which is curious because we're in the summer months when people are outside, but arguably in some areas, people are back inside because it's warm and you've got air conditioning, or just the very nature of the virus because it mutates and it's looking for hosts, that we're having a rise yet again in infections. So the mandates remain. I'm looking to advance our screen again. There we go. EEOC guidance, like I said, came out in December. They refined it in the spring of 2021. And the interesting thing about that is with regard to the religious exception. Remember, when the EEOC first gave its guidance on the religious exemption, it was the employee has to have a sincerely held religious belief, and it has to be documented somehow by either a priest, a rabbi, a minister, saying, yes, he or she attends my congregation, and there's something in our specific teachings and writings of the church that, or the religion, that prohibit the getting the vaccine. And then EEOC revised it, saying, actually, an employee could depart from the teachings of his or her church, and it could be because people are having difficulty getting that somebody to attest to the fact that they're a member of the congregation, or saying that, you know, the way I interpret the teachings of my church may be different from somebody else. And the example I like to give is the Catholic Church has its position with regard to reproductive rights, of course, and its abortion stand. And there were a lot of questions with regard to fetal cells being used in the development or production of some of the vaccines. And but then the Pope came out and said, get the vaccine. So the EEOC responded, and it wasn't exclusively because of that, but it was certainly influenced by that. The EEOC came out and said, you can depart from the teachings of your church and still have a sincerely held religious belief. Well, that made it difficult for employers, of course, because how do you judge someone's sincerity? And employees were, and we've seen lots of these, were citing to, you know, for purposes of Christians, Old and New Testament, for purposes of others of other faiths, or just simply of not having an established religion, but basically say, this is what I believe, and made it very difficult for employers. But the next angle in that regard was not so much that this is my sincerely held belief, but the second part of the analysis, just like with the medical exemption, was, okay, assuming we allow you not to get we waive the vaccine requirement with regard to you, can you still perform the essential functions of your job with this accommodation? Now, it's a different standard between medical and religious. Medical is you use your standard ADA type of reasonable accommodation, undue hardship analysis. Under the religious exemption, it has to be more than a mere inconvenience. You have to really point to a true undue hardship. And that was difficult for some employers. And some of those cases have been challenged going forward. But and those are legal challenges, not only to the vaccine policies, but the way in which the employers dealt with the interactive process back and forth with employees and whether or not they could accommodate them. So path out of the pandemic, you got more clarification from federal agencies as well. Certainly there were legal challenges and confusion, not only with the CDC and with OSHA and otherwise with regard to the vaccines, because in the summer and fall, late summer and early fall, infections continue to rise. Next slide. And then we had the Supreme Court early in January of 2022. In a 6-3 decision, they stayed the large ETS OSHA mandate, saying that OSHA exceeded statutory authority. Now, OSHA immediately went back to saying, okay, let's take a look at what we can do. And that still hasn't happened. They have not issued a new ETS with regard to, and remember, ETS has a limited shelf life anyway. After the emergency period has passed, they have to go back through standard rulemaking. And I think that that's where OSHA retreated back to looking at, let's go through a longer term standard. Now, that being the case, it all depends upon the trajectory of the virus. And right now we're dealing with increased infections with one of the variants or two of the variants. But the question is whether or not OSHA will come out with a new standard. I think what I would say is look to the fall of this year as to whether that they do, because they are certainly working on something. And then with regard to the CMS, however, the Supreme Court allowed that to stay in place. What is that? That's again for healthcare providers, meaning it provided new standards and it depended upon which state you were in. New Hampshire had a different standard than other states, but for covered employees, for healthcare employers who were covered by Medicare, Medicaid, it was a question of whether or not they were vaccinated, and if they're not vaccinated, they had to be vaccinated, whether or not they fit within one of the two exemptions, and if they fit within one of the two exemptions, whether or not there was a reasonable accommodation where they could continue to perform their job as required. The biggest issue in that regard really is remote work and whether or not somebody can continue to perform their work, because the efficacy of the mask, depending upon the environment, it's not nearly as good as the vaccine. And the EEOC and CDC have not recognized the effect of what's called hybrid immunity, which is someone who's had the vaccine and or had the virus, and with that had certain antibodies. They have not recognized that, and although that is something you've probably heard a lot in the workplace. So healthcare employers can certainly have the vaccine going forward, the vaccine mandate going forward, and that's where we are to today. Next slide. So the rise of the variants, it's Alpha, it was the original, then Delta came next, then Mu, which nobody really talked about, but that was there for a period of time. Then Omicron, that was really sort of the dark side of the empire coming out. Omicron was the variant that really hit hard last fall and early this winter, and it burned out effectively by late February, early March, as they predicted. But then you got BA2, and we're now up to BA5, and as I mentioned earlier, of course, now the latest, monkeypox. Now, obviously, monkeypox is not spread, as far as what they know, anywhere near the same way as the respiratory virus that is COVID. But that being said, it's certainly something to be addressed. And there is a vaccine. Thankfully, there are therapeutics for monkeypox, as there are, of course, for COVID. But that being said, the CDC, of course, is now responding to the increased numbers of monkeypox in our population. So what are we dealing with now? We're dealing with, thankfully, hospitalizations, and certainly deaths have been declining with these variants. They are more transmissible and generally less serious, although actually as recently as this weekend, one of my kids came down with it, and she'd been dodging the bullet. She'd been twice vaccinated, of course, and boosted, but still got tested positive for COVID, and was fatigued, but also the symptoms were upper respiratory cough, congestion, and so on, and slight fever. But more therapeutics available. The one thing to mention with regard to the therapeutics, however, is the rebound effect. And why do I mention that? Not because I'm a doctor or I play one on TV, but instead because of the impact upon the workplace. You've got an employee who tests positive for COVID, is suffering those symptoms, is quarantining, then isolating, and then you say you can return to work, and the person is returning to work perhaps a little bit sooner because they've had the therapeutics. The problem with some of the therapeutics is there's a rebound effect, where after a period of time, sometimes as little as 5 days after the end of the symptoms come back again. And that could affect, of course, the person's attendance. And then the other is with regard to mask and vaccine mandates. Some employers shelved those. They said, we don't need masks in the workplace anymore. We're going to drop our vaccine mandate. Some have done that, certainly. But except, like I said, for the CMS and other related workplaces, at least for now. And so, because we could be going back to, and some employers are actually stockpiling masks, thinking that by late summer, early fall, we could be back into a situation where we're looking like we did last year at the fall of 2021. So what do we do now? Well, you continue to monitor the infection statistics. And I guess what I would say too is don't drop your safety standards. Your safety standards need to remain the same, meaning follow the CDC guidance and look at, if someone is exposed to, if someone is traveling a great deal, if someone is symptomatic, don't just simply say it must be allergies, which of course many of us are experiencing, as you can tell by the bags under my eyes and the amount of pollen that's out there. But you can't simply say, and of course we were wearing masks for 2 years, and so people are getting colds and things like that, other infections. Recently, I had an upper respiratory infection, and thankfully tested negative not once but 4 times for COVID, but in a 10-day period. But that being said, you can't let your guard down. So you still have to have those same standards of where you may not be taking temperatures like we did back in 2020. You're still certainly saying to employees, if you are symptomatic, if you've been exposed to someone who has COVID or suspect to have COVID, this is what you must do. And then review your state-specific standards. And for a lot of people on our program this morning, and we've got over 300 people online, that you have to look at the standards state by state because they do vary. California, New York, and even parts of Massachusetts, we're dealing with different standards right now because of the trajectory of the virus. And then, as I think I mentioned before, can you still have private mandates, meaning your vaccine mandate? Yes, you can, if it is job related and consistent with business necessity. So other developments. Our friends at OSHA, the Occupational Safety Health Administration, which is a wing of the Department of Labor, U.S. Department of Labor, was actually very busy during COVID in 2020 and 2021, doing workplace audits, safety audits. And they did everything from looking at standing desks, looking at screening procedures in the workplace, one-way corridors, single-use bathrooms, density in rooms and workplaces, and so on. They were very active in that regard, and they were following religiously the CDC guidance. And then when CDC changed, they still stuck to a stronger standard. Again, this is a safety wing of the Department of Labor, and they are very technical. So employers were hit with fines or threatened fines when you're dealing with issues related to our employees wearing masks, if employees are sick, if you're not screening them, and so on. And look for OSHA to continue to be busy in the months ahead with regard to sort of the tail of this virus. U.S. Department of Labor and New Hampshire Department of Labor were also busy doing wage and hour audits. And what were they doing if people were generally not in the workplace and then working remotely? Well, one of the issues was reporting time. In New Hampshire, you have the issue of the 2-hour reporting time when the employer requires the employee to come into work and with an expectation of working more than 2 hours in a day, and usually it's anywhere from 4 to 8 hours in a day, and the employee says no need to come in, the employer says no need to come in, then the employee is either paid at a default of 2 hours, we're talking about a non-exempt employee, paid a default of 2 hours, or the employer can put the person to work. Now, how does that apply to a remote workplace? Well, that's a curious issue because the law hasn't caught up with that. And Department of Labor, New Hampshire Department of Labor acknowledges that. So they look at when did someone log on, when did someone go through a training session, when did someone, perform any task related to their workplace. And they were active in that regard. Thankfully, the Department of Labor was also receptive to a change in the statute to acknowledge the relationship that employers have with remote workplaces and the expectation of work, and whether or not the employer, if the employee is logging on at all sorts of times and has a less than and standard work expectation in hours, whether or not the employer had to pay the reporting time too. But then also you had U.S. Department of Labor out there doing audits, looking at everything from temporary or contingent workers to looking at overtime issues, and to looking at overtime issues specifically related to discretionary and non-discretionary bonuses and how they impacted the regular rate for purposes of overtime. Joint employment and independent contractor rules under the new administration, under the Biden administration, have been basically flipped from where we were with the Trump administration, meaning there's more of an emphasis on if two entities, workplaces are working together and in concert, whether or not their total workforces are counted together, and whether or not the acts of one could be imputed to another. And we've seen more and more of that. And we've also seen where the Trump administration was a bit more relaxed with regard to independent contractors. This administration is focusing more on misclassification, which is usually the standard of, does someone meet the fairly rigorous standards of the IRS, the U.S. Department of Labor, and so on. And there are several other tests as to whether or not they are exempt from wage and hour, benefits, discrimination laws, and so on, or they're covered. And this administration is looking to find more of the misclassified workers who are treated as independent contractors, who should be treated as employees and therefore covered by this myriad of federal and state laws. A new paid FMLA, Karen Whitley at our employment law seminar last month, and also for the high tech exchange, talked about that and the differences between the paid family leave, specifically in New Hampshire, and also in Massachusetts, and Massachusetts being very different in that regard. And the angle on that it also is whether or not a remote employee is covered by that, someone working from home in Massachusetts, where they would typically be in the office in New Hampshire, whether or not that and other laws in Massachusetts would apply. And the answer is it depends on the frequency and the employer and the frequency of the work done in Massachusetts. And that's true with regard to tax withholding and lots of other issues. But it's not just Massachusetts and New Hampshire, it's many other states that have in the last 2 years adopted these new paid family leave, paid sick leave, paid paternity leave programs that you must, as a multi-state employer, pay attention to. Perhaps it is reflective of COVID, but it also is perhaps just reflective of our a culture shift in our country, where we're looking to, are the leave programs we have antiquated, and do they need to be more encompassing of the reality of the new workplace and the new family structure, or just neglected needs for families over the years. Has the country gone to pot? That's a very good question. More states legalize marijuana. We are up to 40 states and the District of Columbia with one form or another of legalized marijuana. Cannabis use truly skyrocketed, as did alcohol use during the high points of COVID. And the question is whether or not the federal government will change its position. And what I mean by that is under the federal drug laws, not necessarily with regard to what's happening in Congress right now, which I'll talk about in a minute, but whether or not the federal drug laws are going to change for purposes of how they're enforced. There is a thing called the Cole Amendment, which came up in the Obama administration, which basically was in the early days of the first 4 or 5 states that legalized marijuana. The question was, how do we treat federal law, especially with regard to the border states when people are coming into those states to get access to marijuana, which they otherwise wouldn't have in their state. And the Cole Amendment basically came from the Attorney General's office, U.S. Attorney General's office, and said, look, as long as you enforce your state laws, then we won't enforce federal law in your state. But that changed during the Trump administration. It looks like the Biden administration is basically going back to that, at least for now. But this has not been a priority for this administration. Of course, there are lots of other things that this administration has had to deal with. But the question is, in the meantime, are employers waving the white flag? Are they basically saying, we don't care? With low unemployment, with vacant positions, with a need to basically deal with a need to stay productive, do we care in our workplace for certain jobs, whether or not people have been off-duty hours, enjoying whether it's legal or illegal marijuana? Do we care? And a lot of employers in the last 2 years have dropped their pre-employment testing for marijuana. And there was actually a bill in the legislature. No, there were 7 bills in our legislature in New Hampshire. Remember, New Hampshire is the only state in New England that does not have recreational marijuana, legal recreational marijuana, I should say. We have medical marijuana, and that is highly regulated. All of the surrounding states and all of Canada have recreational marijuana. And of course, in our state, we draw upon those states. Someone could live in Massachusetts, Vermont, or Maine and work in New Hampshire. And the question is, what are you doing with regard to your testing? And a lot of employers said, you know what, I'd rather fill the position. Unless it's a safety sensitive position, I don't care. So that's sort of the reality, sadly, of the confusion that's in the workplace. And there may be a resolution. I don't think it's going to pass through this legislature. In fact, I'm certain of that in New Hampshire. And the governor has made his position that he's not going to sign a bill legalizing marijuana, believing it is a gateway drug. The new marijuana is a gateway drug to something more difficult, more challenging, by way of narcotics. But in the meantime, employers, I think, are taking a very different position with regard to marijuana in non-safety sensitive positions. So what am I talking about here? And it's because of a tight labor market. There are a lot of tensions in that regard. Are employers requiring now, look, you had 2020 and 2021 where you were not at your desk, you're not in the workplace. There certainly were more COVID issues, but we need you back to work now. We're paying for some expensive commercial real estate. We want you back to work. And there, you know, I'm talking in New Orleans. One of my talks is going to be on the challenges in managing a remote workplace. But a lot of employers are saying, come back. But there's also there are a lot of employers that say, look, you can work indefinitely remotely. Google, Siemens, and others, I think Facebook, Oracle are all saying, you know what, we don't care as long as you get the work done. But others, including our friends at Tesla, are saying, come back to work, and we expect you back to work soon. At the same time, I think that Elon Musk was also saying we're going to reduce our workforce by 10%. So perhaps if you're working for Tesla, say, maybe I ought to go back to work until I get hired by Google. So I think that's a tension we're seeing going forward. There was a magazine out where CFOs and CEOs were polled, and they said, we think that remote work, people lack hustle. I want to see more people back in the offices, at least on a hybrid basis. So that is something that is going to be a challenge going forward. And the question is, if you've allowed remote work as an accommodation, is that to be indefinite? And no workplace accommodation has to be indefinite under the ADA, as you know. But the question is, culturally, for purpose of your business, are you going to allow that? And of course, the questions there are going to be, if I allow it for one, do I have to allow it for another? And that's up to you. If you adopt the ADA standard, it's like every situation is unique, but that's not dealing with the grousing in the workplace where someone says, well, why is he allowed to work remotely? Or why is she allowed to work remotely? I want to work remotely too. And that's the challenge in this tight labor market, because you're finding many more employees, perhaps because of the COVID experience, saying, you know what, I actually like working from home in part. And also with higher gas prices, I prefer not to drive in as much. I probably burned more gas than I needed to this morning as I was trying to accelerate around slow traffic. But that is remote work is going to be a real big challenge going forward. I'm going to talk about that in a minute. But wage inflation is also an issue. And the issue there is you've got your competitors are paying more. I mean, not to say your competitors are McDonald's, but you look at McDonald's, they're paying a very high wage, starting wage. Certain warehouses nearby are advertising $18 to $20 to $25 an hour. So if your lower starting wage is down, and of course we know that our minimum wage is at $7.25 both federally and in New Hampshire. If you're paying much more than that, then your competitor is going to pay a bit more than that. And so if you haven't seen ghosting yet, you certainly will. If you haven't seen some employees that are jumping to another workplace because they're getting a sign-on bonus, perhaps, if you haven't seen it yet, you likely will. Low unemployment, we were at 3.6 nationally, 3.6% nationally, but in New Hampshire, much lower. But our labor participation rates remain in the 60 percentile as well. The question there is, so what do we do? How do we track? How do we maintain? Because if you go back to wage inflation, how do we maintain a workforce when if the lower tier is bumped up, then the rest of the compensation system is bumped up as well? And at what point does that affect your commodity or services and make you, it's something where it's not necessarily sustainable, at least that we think at this point. So it is difficult in that regard. And then, of course, that goes back to recruitment and retention being difficult because one tied to wages, two tied to benefits, three tied perhaps to remote work and other accommodations. It's a difficult market. I'm not telling you anything you don't know, but that does reflect in agency guidance and in the legislative process. So rising tide of workplace complaints, are we seeing more and more? Typically, when you have low unemployment, you have low numbers of or lower numbers of discrimination claims. They drop off. Why? Because people have other places to go work. I don't need to suffer here with this sexual harassment or this age discrimination or this disability discrimination. I can go somewhere else. I'll be treated better and perhaps and better compensated. But we're not seeing that. We're seeing a steady rise in or a plateau of certainly not a decrease in discrimination claims. Why? We're seeing a lot more, continued more retaliation claims, and they could be tied to workplace complaints, and they could be tied to COVID-related issues. So what am I talking about there? Vaccine mandates. Someone's religious or medical exemption was denied, or the accommodations were denied, and people are filing claims in that regard. We're seeing more of those. We're also seeing whistleblower claims. The whistleblower claims typically are under OSHA, where someone alerts an employer to a workplace hazard or safety issue, and they believe something bad happened to them as a result, either termination, discipline, change in status, compensation, and so on. So there's an unsettled state with regard to the workplace. And I think largely it's because I describe the last 2 years as people walking around with clenched fists just because of the uncertainty of the virus, both physically, mentally, and financially. And so we're seeing more and more some of these are lagging indicators, but we're seeing more and more claims. So some of the issues on the horizon, Congress has considered for some time a response to the age discrimination standard, because the issue there is that the FLP Gross case of the Supreme Court of several years ago changed it to that age discrimination must be the reason under federal law, must be the reason for the claimed discrimination, not one reason, not a contributing factor, but the reason. And that's why among the most common workplace discrimination claims, age is not even in the top 5 or always in the top 5 because it's a difficult standard. So Congress has considered again this year to look to change the age discrimination standard. Now that has not been, with our aging workforce, that has not been a priority for this Congress because again of other more pressing issues. Increased minimum wage. We can all agree that $7.25 is a ridiculously low wage, and especially if you have a tipped employee where he or she can make 45% of that, again, in tipped workplaces, That's a very low wage. Other states and other cities have increased their minimum wage 15 or more dollars per hour. There have been proposals on a federal level and on a state level to increase the minimum wage. And I think we'll likely see something coming out of this Congress or the next. And certainly perhaps even in our New Hampshire legislature, an increase. Federal legalization of marijuana, entirely possible. Several of the presidential candidates last time round advocated for a legalization of marijuana. At this point, we're saying 40 plus states have it. Why wouldn't you have a national standard like they have in Canada? And that's entirely possible as well. Amendments to the FMLA to broaden it further, perhaps. There actually have been a few bills in Congress in that regard to extend to other family members or extended family members, but also perhaps making it paid FMLA. As you know, it is unpaid on a federal level. But some states like Massachusetts have paid FMLA, and that's entirely possible. We could be looking at that. Those bills have been in Congress. And again, in New Hampshire, you have paid FMLA, but that is something that is on a voluntary basis and deducted from the employee's paycheck. PPP audits, that's entirely possible this year. You could be seeing that. Because of the amount of fraud that went on with payroll protection loans, and the federal government is catching up with those. Interstate tax battles were really principally relate to remote workers, where someone is working in a state like Massachusetts, where their workplace is in New Hampshire. And the question is, for purposes of withholding tax and benefits and so on, what applies? And we'll see more of that going forward with more remote work. And so your payroll company, if you use HRS or another payroll company, ought to be up to speed with regard to what does it mean and what are the thresholds when someone is working out of state or in a different state. So the question is, has COVID truly changed our workplace as many more employees continue to work remotely or request to work remotely? Is that going to be a forever situation, or is that going to be the end of COVID? And like we saw with Elon Musk, no, we need you back to work. Last year in 2021, a survey of HR professionals revealed some of the reasons why employees requested more remote work or remote work. What would you say was the most common? Childcare, lifestyle, meaning I prefer to do this, disability accommodations, whether it's related to COVID or not. And what I mean by that is someone who has perhaps an underlying health condition and didn't feel safe coming into work and had a doctor's note in that regard. Person saying, I'm more productive from home. Not just simply I choose, I like a relaxed environment, but I'm more productive when I can be more focused. And the others, I don't feel safe at work. So most common, by the way, in 2021, childcare. This year, responses changed a bit. And what was the most common response in 2022 so far with regard to people not wanting to return to work? I forgot where the office is located. That, of course, is silly. I didn't trust the vaccine. Remember, in 2020, employees said, I'm not coming back to work until there's a vaccine. And then some said, I'm not coming back to work because I didn't trust the vaccine or because I can't get the vaccine and I need an accommodation, and my accommodation is remote work. And one that we've heard most recently is gas prices. And a lot of employers are responding to that saying, you know what, we're going to allow at least hybrid activity or for a period of time because of the skyrocketing gas prices. So any of those sound familiar, or perhaps all of them? So, you know, what we has been coined now, the Great Resignation, is the average rate for in 2021 for unemployment was 3.9. We're at 3.6% now. And in December of 2021, 4.4 million Americans left their jobs, another 4.2 in January, 4.3 in February. In March, it was 4.3. In April, it was again. In May, it was again. May was 4.4 million Americans left their jobs. Now, where are they going? You know, you have again, record low labor participation rates at 61.9%. You have low unemployment, you have wages on the rise, and there are so many vacant positions. So the question is, are people remaining out of work purposely? Not necessarily. What they're doing is they're jumping from one workplace to another. And the term ghosting was something that became very familiar in 2021, and it continues to be an issue as you've got a nomadic workplace jumping from place to place, chasing the higher wage and perhaps chasing different work conditions. 11.4 million available jobs in April of this year. And again, 4.4 million quits in April, and then again, the same number in May. And national unemployment, like I said, at 3.6%. And vacancies outnumbered unemployed by 5.5 million. That is, I mean, again, enormous challenges regardless of who is sitting in the White House, regardless of the composition of Congress. These changes are historic. These challenges are historic. And I challenge anyone to say that one administration over another could have done an exceptionally better job than another. These are just, there are many different challenges here. And that being said, that means, employers cannot certainly capitulate. They have to stay at it and do what they need to do. But I wouldn't necessarily look to your federal or state government for relief. I think you just have to go this road yourself and do your very best for purposes of recruitment and retention. So where have all the employees gone? Some say back to school, perhaps, especially if they're looking at perhaps having their student loans eventually forgiven. Taking a break to re-examine priorities. We've heard a lot of that. Working for another company who's paid a signing bonus. We've certainly heard a lot of that. Starting their own business. And again, silly thinking that it was in the parents' basement, but some of that. And alien abduction. It likely is a mix of everything except for alien abduction, where it's just employees have, because COVID was a life-threatening illness and to a certain extent still remains that way. And people have looked at, you look at moving from major cities for a number of reasons, moving to places more bucolic and relaxed like New Hampshire, Vermont, and other places. I think that's the challenge for HR professionals is how do we recruit and retain talent in this still crazy environment. Before COVID, only 6% of employees nationally worked remotely. Now, how many work remotely? What do you think? 25, 33, 40%, 60%, or I heard someone say recently 90% because they haven't seen a lot of coworkers in years. And the answer is 33%. But that is changing on a regular basis. And I would say that it will not be unusual to say in a few years that you're going to have as much as 50% of your workforce, at least part-time, working remotely. Are we witnessing that cultural shift? And it could be because, like I said, Amazon, Apple, Facebook, and others are allowing people indefinitely. But there are other executives out there that disagree. And because of the impact on culture, productivity, collegiality, cooperation, and retention, saying that, if someone is working on their own, they're not as tied culturally to our workplace. And there could be some problems in that regard. So a lot of executives have very mixed emotions with regard to indefinite or long-term or extensive remote work. So are we also seeing that same cultural shift? And I think we are, with more states adopting paid family leave laws, new parental leave laws, non-competition laws that continue to be narrowed, like we see in our neighboring state of Massachusetts, where there is garden leave, which is a European concept. You basically pay someone to forbear from working for a period of time. And again, Congress is considering its own paid FMLA. And I think it's all responsive to or reactive to changes in our workplace culture. So the trajectory, of course, it peaked in February of this year. The numbers dropped and the variants were not as severe. However, the question is whether or not this is truly, we've been asking since March, is this the end of COVID? Not so fast. and again, we're seeing that certainly now with the number of people that are getting COVID, perhaps even a second time, or just the rise in the infections if those who are vaccinated are still getting the infection from the variants. So what's the American workforce looking at next? And what we're looking at in June of 2022, what are we looking at? A lot of employers are looking at the smaller workspace footprint. Do we need as much commercial space? And can we do with micro offices? We're not shared spaces though, because that is again, OSHA has said you shouldn't be looking to have people go back and work in close proximity. You want to have some space between them for purposes of, even apart from COVID, just air quality and so on. More employees on the move. Gone are the days when someone works for the same employer for their entire career, or even a few employers in their entire career. More employees value more paid time off than ever before. Again, is that a cultural shift for the American workforce? And some of the skills that we're looking at is we're looking at some of the lessons we learned from the last couple of years, and as employers perhaps move towards automation, again, smaller workplaces, and more flex time, is that going to be the new normal? In Congress, what we're looking at is a couple of bills. There is the Be Heard Act, and that is adding to, and it's a bit of a sort of a potpourri of issues, and some of them I think were sort of unnecessary, but it's adding to Title VII, discrimination on the basis of sexual orientation, which of course the Supreme Court has acknowledged is within the definition of sex under Title VII, gender identity, sexual stereotypes, and a new definition for harassment. And I did harassment training yesterday, and we know what the standard definition is, but this would be a broader one than the standard definitions today, and that it would apply to all workplaces. Of course, Title VII is 15 or more employees. This would apply to all workplaces of all sizes. It would apply to independent contractors, and it would apply to interns and trainees. So that's an issue under the Be Heard Act. I would project that's going to go nowhere. There's the Life Saving Leave Act. And what is that? That is for, and talk about a small subset, but an important subset, for employees that take time off to be donors for bone marrow and stem cell donors. They would get up to 40 hours of unpaid leave, but they have job security that goes along with that, because those would not necessarily be addressed by, because you're not ill, you're providing something to someone who is ill. So that would not be covered by the FMLA. So that might be an amendment to the FMLA, or that might be a standalone amendment itself. The TASK Act is, the acronym stands for Training Assignments for Student Knowledge. And that is, that would be basically treating post-secondary vocational work as not counted as employment. And what does that mean? That's sort of a conservative approach to, look, allow kids, post-secondary kids, to get workplace experience, but they're not covered by workplace laws. That's sort of a throwback concept, but it's an important one as we look at this nation abandoned apprenticeship programs and the like, which got work hardening issues and preparing students for a career, or even to be in the workplace. So that's an interesting one. The Wage Theft Prevention and Recovery Act is not basically what you would think it is. It's a bit of a misnomer. You would think wage theft is basically people, the concept I'm familiar with wage theft is people that basically fabricate their time, and with that get paid more than the hours worked. This wage theft is more the concept of amending the FLSA to prevent wage theft by employers. And the U.S. Chamber of Commerce came out and opposed it because they said it provides no more protection than is already available, and actually makes it pretty onerous for employers going forward. And then the Safe Workplaces Act is the U.S. Labor Secretary, Marty Walsh, would direct OSHA to develop standards to reduce the threat of workplace violence. Certainly, we've seen a lot of violence out there in the workplace and otherwise. The question is what OSHA could do necessarily to prevent that. But it's certainly a laudable concept going forward. The next is with regard to federal agencies. Just the next slide, please. EEOC, new strategic 5-year plan. That's not necessarily anything new. That happens all the time. They just got to the end of their last 5-year cycle. And they're coming up with they're looking at how we treat migrants to the US, how we treat sexual orientation and transgender issues in the workplace. And they're looking at remote work as an accommodation and so on. It's a developing plan, but it's one that always continues to evolve with the EEOC, looking at trends in the workplace. U.S. Department of Labor's position on joint employment and misclassified workers. I mentioned that it's a U-turn from the Trump administration, but it's one that we certainly expected. Looking more at combining entities for purposes of coverage and treatment. And where that comes up with regard to joint employers is perhaps if you have a contingent workforce, you have a temporary staffing agency working with you, and whether or not the host employer is responsible for how the staffing agency treated its workers. We're talking about everything from minimum wage to overtime wages and so on, things that would be covered under federal law. That is something certainly to watch out for if you've got a temporary staffing agency that you're working with. Misclassified workers, again, that's the independent contractor, going back to whether or not some people should have been treated as employees and they hadn't been. That's age old, but it's a new emphasis from a renewed emphasis from folks at the U.S. Department of Labor. EEOC guidance on mandates and exemptions. We saw that again in the spring of 2021. And we're seeing more guidance and refined guidance coming out with our friends at EEOC with regard to religious accommodations. And again, I mentioned the National Labor Relations Act or National Labor Relations Board reversal on Trump era positions. That's to be expected in the next administration. Should there be a change in the majority party, that would likely happen again. We've just seen it from, for the last 20 plus years. And OSHA's ETS and workplace audits, I think they're going to continue. They're just sort of retooling based upon the experiences with COVID and other workplace hazards. And then the workplace bills in New Hampshire are pretty interesting because we're coming to the end of the session. And really what's been left over, again, the session starts basically in October, November, when the LSRs are filed. Then their things are further refined. Then you've got House bills, you've got Senate bills, and in April there's a crossover. What's passed the House goes to the Senate, what's passed the Senate goes to the House, and then there's compromise. Things go to study committee, the bills are killed, things are put off or combined, and then they end up on the governor's desk if they pass through House and Senate through some form of reconciliation. The first is with regard to repealing the Granite State Paid Leave Program, which was a compromise because there had been a move for the last couple of years to have a paid leave program in New Hampshire. There was a lot of resistance to that. The governor proposed his own with regard to public sector employers in the last session. This session was, okay, we'll have a paid leave program, but it's voluntary and it's limited. And there is a legislative attempt on both sides of the aisle, Republican and Democrat, to repeal this. One saying it goes too far, the other says it doesn't go far enough. But that will go nowhere, I think, in this administration. Increasing the state minimum wage, there are always bills in that regard. Our minimum wage is ridiculously low at $7.25, but there is resistance to changing that right now, given what's happening in the economy. I don't know. It's not a starting wage for most workplaces, and it's interesting that that's where there is that strong resistance to changing that. There were bills to go anywhere from $7.25 gradually up to $12.50 an hour, but that's, again, I don't think that's going to go anywhere. And also, what's not going to go anywhere is the 7 bills related to the use, sale, or cultivation of cannabis for personal use. Not this time around, I don't think. We won't see that. There have been changes with regard to medical marijuana, but not with regard to recreational marijuana, even small use. Unenforceability of non-compete agreements with regard to termination of employment for non-compliance with a vaccine mandate. That's for employers that fired employees for not complying with their vaccine mandate, but then holding their feet to the fire with regard to restrictive covenants like non-compete, non-solicitation, and so on. The State Council was active in that regard, so was the BIA. Andrea Chatfield, I know from Mara and State Council, was active in that regard. And that bill was effectively killed. That was not a well-drafted bill, and it was confusing in the way which was going to be applied. And it's combining two concepts of the employer's need to protect its intellectual property and its business with the employer's interest in protecting its workplace with a vaccine mandate. It was an awkward bill to begin with, but that was one where there was resistance from the business community, and that bill failed. Criminal background checks for healthcare workers. That's an interesting one, which basically says there's a backlog, and perhaps you've experienced this too, in getting the results of a criminal background check, but I need to fill a position. So it was a temporary employment in residential care. What we're talking about there is basically nursing homes, assisted living facilities, as an LNA, as you wait for, LNA being a licensed nursing assistant. So lower level, while we wait to see if the person passes the criminal background check. That's interesting. That's basically a desperate move by healthcare employers to get people at least in the door while we wait, assuming that they're not going to do any real damage as an LNA. And so that one actually has a chance of passing. And then the other is, which makes perfect sense, employment restrictions for those who are sex offenders, that they cannot work in an environment, an employer cannot hire them, and they cannot work in an environment where they may have access to minors. I mean, that makes absolutely perfect sense. And I'm surprised that would even be an issue that we'd have to address legislatively, but that is. And then finally, there was a bill. It was Senate Bill 296, and that was that under the New Hampshire Commission for Human Rights would take away from employers the ability, once there was a probable cause finding in a discrimination case, to have the matter go, have it stay at the Human Rights Commission as opposed to employers, as it is the current case, being able to remove it to go to court for basically starting the process over again. I testified on that, so did some other employment lawyers and the BIA. There was a lot of back and forth in that, and that bill was killed. That would have been an uneven playing field for employers going forward. So that thankfully was changed. Regulatory, New Hampshire Employment Security is still doing their CARES Act audits because of fraud and mistakes with regard to use of unemployment funds, state and federal unemployment funds. The New Hampshire Commission for Human Rights is dealing with their backlog of cases. Some cases go pretty far back, but I just saw something recently said in Massachusetts, there's as much as a 7-year backlog in discrimination cases. I've had a few cases that were 4 and almost 5 years back, but the new executive director at the Human Rights Commission is doing, and her staff are doing an exceptional job trying to reduce the backlog either through mediation or through moving cases along that it's been stalled because of staffing shortages, and also just simply the number of discrimination cases that have come in with their limited staff. The New Hampshire Department of Labor has a new wage and hour administrator as Michelle Small retired after a long career, an exceptional career. And they're out doing more training sessions again now that the COVID numbers have changed. And again, they have a renewed focus on misclassified workers. According to Better Works, the most challenging issue for HR professionals faced in 2021 was recruitment and retention, implementing and enforcing COVID safety policies, translating CDC and OSHA requirements for the C-suite. In other words, having that information go up to the C-suite for them to understand and implement, flexibility with remote work accommodations, or all of the above. What do you think? And the answer was, next slide, all of the above. I think those are the challenges that all of you folks have faced and will continue to face to a certain extent. And next slide. So remote workers, let's talk about that for a minute. The most challenging issues with regard to remote workers is perhaps continuity, communication, and dealing with the C-suite as to, look, this is what we need to do to maintain our workforce. So some tips for managing remote employees: review your job descriptions and the jobs that can truly be performed remotely, at least in part, the hybrid arrangement. Clearly communicate the hours of work, the days of work, and other expectations. Why? Because you want to avoid that situation with the Department of Labor where someone is claiming overtime when they didn't clock in, they didn't clock out, or there were episodic or sporadic emails or texts that the suggestion is the person worked a much longer day than perhaps they did. Reinforce company policies and workplace issues. Why? We've seen a marked increase in sex harassment and other misconduct claims from remote workers. People being more relaxed and sending things over company communication systems. But the other part of it is simply other workplace policies, whether it's FMLA or other types of paid leave, use of company equipment, and so on. So if you provide the equipment, address and confirm how it's to be used and confirming those policies. Promote regular communication and integration. Don't assume that because a person's working remotely, you don't have to deal with them. Managers need to be trained in that regard, not only with regard to regular communication, but also training the employee that he or she has to be in regular touch with you. And that's for integration purposes, but also continuity. As President Reagan once said with regard to the Soviet Union, trust but verify. Yeah, you should trust your employees. You're dealing with adults, but also verify that they're following workplace policies, that you're monitoring activities online, and that you're also making certain that they're recording their time if that applies. Focus on output more than progress, a process rather. Sure, if that applies to your workplace, and work with managers on an updated performance evaluation methods, because that certainly is something that has to apply, because the way in which you manage employees is not exactly the same in office or in facility as it would be if they are remote. And reserve the right certainly to revisit remote work arrangements as your business needs change. And yes, embrace the future because it is here. So in conclusion, and thank you for being part of that and putting up with some of my technical gaffes and my traffic issues this morning, but COVID certainly has turned our world upside down. Our workplace was not immune. No workplace was immune. But it's shown us that, I think, especially with HR professionals, that we are resilient. And the new normal, especially with regard to remote workers, I think is here. I don't think we're ever going back to a 100% in the workplace, in chairs. But that may be certainly fine. So employers, to thrive, I think it's fair to say, need to adapt, and I'm confident you certainly will. Challenges remain, but I think it's fair to say that if we've overcome what's happened so far in the last 2 years, something that's truly historic, there's no question you've got the tools, experience, and know-how, and again, resilience to do just about and deal with just about anything. So I thank you for your time this morning. Look forward to, you'll get a poll soon with regard to what we're looking at for the fall and next year for the high-tech exchange. Look for more information on LaborNet, and we will be in touch with, there are credits for this program too, HR credits for this program, and there it is. There's a certification. Thank you, Liz, for your participation this morning. So thanks so much. Enjoy the rest of your day, this midweek point, and go Celtics. Thank you.